Hello, and welcome to Navigating Estate Planning with Caress Law. I'm your host today, Tammi Caress, and we are talking about the exciting subject of intestacy. What does that mean? Intestate succession. What does that mean? Well, we're going to find out today and dive in right now.
And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much.
I had a client who, he wasn't my client, but I had a person who died and I was helping with the probate. And this was a long time ago, not in Oregon or Washington, but the law there was a little bit more favorable than here. But nonetheless, this person died, told his family what he wanted to happen. He had a wife of, I think, around 25, 30 years. His wife basically helped raise his children from the time they were toddlers. And his wife thought of these children as her own. Well, the house that she lived in all of her adult life was owned by her spouse, and her spouse died. Those children kicked her out of the house so that they can have their share under the intestate laws. This is against what he wanted. We know it because it was in writing, but guess what? It was not a will, and therefore it wasn't effective. So not only did my client lose her spouse, she lost her house. And even more devastating to her is she lost the relationship that she had with these children that she had helped raise and that she loved. I mean, that was the worst part of it. It's a really terrible situation. And frankly, I think really terrible children, but something that could have been avoided had this person actually put his wishes into a will instead of just verbalizing it with his family and writing it down on a piece of paper. Intestacy, or dying intestate, means that a person has passed and they don't have a will. Dying testate means a person has passed and they had a will. So what's the difference? Well, you're going to find out there's some different processes through the court, but also a person who dies without a will doesn't have a choice as to who inherits from them. The state makes that decision for them. If a person dies with a will, those who were named under the will generally are the ones who will inherit. So that person made a choice of who their beneficiaries are. So who inherits when a person dies without a will? The answer is typical lawyer answer: depends. Depends on the state that that deceased person lived in. Now, state law will control and dictate, and not all states' laws are the same. So, and you'll find here, I'm going to give you a few examples for Oregon and Washington, which is where myself and my other lawyers are licensed. There are differences in those states, but it really depends on the state that the deceased person resided in or potentially owns property in. So I'm going to go over Oregon. I'm trying not to get too in the weeds or complex here, but let's talk about it. So it really depends who is surviving you and how that person is related to you. We always look at primarily the first piece of information we find out is if the person left a surviving spouse and if they left descendants. Descendants essentially are children, and it's your lineal descendants. So it could be your grandchildren, great-grandchildren, etc. Okay. So if in Oregon, for example, a person has a surviving spouse and no descendants, then the surviving spouse inherits everything. That makes sense, right? To tell you or show you a little bit of a difference, in Washington, the surviving spouse does not always inherit everything. In fact, if there are no descendants and there is a surviving spouse, but in Washington, that deceased person has parents that are living, well, the surviving spouse may not or has to share the separate property of the deceased person with the deceased person's parents. So, and I think about it in this way. I have a spouse, and, if I don't have descendants, any living children, I do have a father that has survived me, by the way, by adoption. So, a little bit about me now. So my family, if I didn't have a will, that's an interesting one. So if I was a Washington resident and I passed away, 100% of my community property, which I'll talk about in a moment, would go to my spouse. But then only 3/4 of my separate property would go to my spouse. My other 1/4 would go to my father by adoption, who survives me. It's kind of weird. My 80-year-old dad is getting some of my property. I think that's just really strange, but anyway, that just kind of shows you a little bit of the nuances. So in Oregon, if a person passes away and they have a surviving spouse and they also have descendants that are living, we look at the relationship between the descendants who are living and the surviving spouse. So if surviving spouse and deceased person had kids together and the deceased person had no other children from another relationship, then the surviving spouse will still inherit 100% of the estate. In Washington, that is not the case. In Washington, if the deceased person has a surviving spouse and also has living children, doesn't matter if it's with the surviving spouse or with from a prior relationship, then the surviving spouse is splitting the separate property of the decedent 50-50 with the spouse and the children. So that's an interesting twist, right? Okay, so I did talk a little bit, I did mention community property, and I'm not going to go into this episode regarding community property, but just to give you a little bit of insight and background, Washington is what we call a community property state, and there's only a handful of states that follow community property laws. Essentially, community property is not separate property in Washington. So an example is, if you're living in Washington and you are married and say you've been married for 20, 30 years, and basically everything that you own or that you worked to build up, all your wealth, you share with your spouse or purchased with income earned in your community property state, it is deemed owned 50-50 between you and your spouse, an undivided 50% interest. So an example could be that, you and your spouse early on saved up all of that income that you earned while living in Washington or that community property state. In Washington anyway, income is deemed owned 50-50 with your spouse, unless you agree otherwise. But again, I'm not going to go into that in this episode. Then it is deemed owned 50 or is deemed community property, and you each own an undivided 50% interest. But now let's just say that you're still been married for 30 plus years and you have inherited from your parents or a loved one. Inheritance in Washington is not community property. Now, it can be commingled with community property and converted to community, but again, different episode. So let's just pretend in this example that a person in Washington or a community property state inherited assets and they put them in a bank account in their own name and they never commingled it with their spouse. Well, that's considered separate property. So in Washington, community property, when a person dies without a will, goes 100% to the surviving spouse. That's just the rule, okay? Separate property, if there are children or grandchildren living, then 50% of that separate property will go to those children or grandchildren when the decedent left a surviving spouse. If the decedent did not leave a surviving spouse, if the descendant left a surviving spouse, but no living children, grandchildren, etc., then 3/4 of separate property is going to the surviving spouse and 1/4 would be going to living parents. Okay. So some nuances to think about or to know. Now, it actually goes even further down the line. So if there's no surviving spouse, we're looking to see, are there children or grandchildren that are living? Well, then it gets divided among them. If there's no surviving spouse and there's no children, then we're looking to parents of the deceased person. If there's no parents, we're often looking to siblings. If there's a deceased siblings, we're looking to see if they have children. And so it gets further and further divided from there, but I'm not going to bore you with all of the details. Again, it depends on state law, but it really can go out very far down the line with intestate. So what does that mean in terms of distribution of those assets? So state law determines who inherits under intestate statutes, but how do they inherit? Well, it goes through probate. Now, probate is that court supervised administration that is required when we have probate assets and a person dies. If a person dies with a will, that will is going through probate and the beneficiaries of that will inherit. If a person dies without a will, they still go through probate, but those heirs, I'm just going to say heirs, are those who would inherit under state law with intestate. So to know a little bit more about probate, I highly recommend you go back and listen to some prior episodes. We also have a ton of on-demand webinars online that are free where you get to learn a lot about probate. But here, probate assets, just real quick, probate assets are assets that pass pursuant to probate laws, but they're assets that are usually owned in the deceased person's individual name. It is not jointly owned with rights of survivorship, and there's no beneficiary to the asset. So a really common asset is a home. You own a home, it's in your own name, or maybe it's in the name of you and a deceased spouse, but you inherited it, whatever. If it's in your own name, then it's a probate asset governed by the will, or if not, governed by state law in terms of who inherits. Okay. So probate, which I'm not a super big fan of if you've listened to my prior podcast, but it's even worse when a person dies without a will. That's because oftentimes courts require a bond. So a bond is kind of like insurance. It is required of your executor, also called personal representative, the person you are appointing to do all the things necessary to settle the estate, pay your last taxes and expenses, and get your assets out to your beneficiaries. or your heirs. Okay. So the personal representative a lot of times is required to post bond. That means before the court gives that person authority to probate and administer and settle your estate, that they have to, with their own money, go and pay a premium for a bond. And that bond can be expensive. It just depends on the value of the assets. So if you have a $500,000 estate, that personal representative who is willing to serve has to go pay a premium so that if they take the money and run, there is money available under that bond to pay the beneficiaries and the creditors and the heirs and so forth. So can be an expensive endeavor, and you're requiring your personal representative to have to come up with funds for their own money. And it delays things and requires more paperwork, which makes the probate process even more expensive. Now, a bond can be waived if all of the heirs who are inheriting agree to waive it. Okay, so a lot of times it can be waived. Now, just know when it comes to probate, many courts, even if it is waived, they do have the power oftentimes to say, well, we don't care, we're still going to require bond. And a lot of times it's because they're looking after those creditors or looking out for those creditors. So not always a guarantee. Now, in some states, Washington being one of them, if you cannot get waiver of all the heirs, then you'll have to have a court hearing. And the court will determine whether you have to have a bond and give notice to all the parties and all that stuff. So anyhow, every state is different, but it's just another expense and delay to settling the estate and ultimately getting those beneficiaries their inheritance. The other issue that happens with intestate estates is the appointment of the personal representative and who that can be. So a lot of states have a priority of appointment, and it depends. If there's a surviving spouse, there might be a time period where their surviving spouse has priority to be the personal representative, and they have to submit paperwork to the court to get that, or other people who would be a personal representative have to wait before they can apply to the court to serve as personal representatives. So sometimes we're playing a waiting game again. So just some of those issues to go through. The other thing that could happen is a restriction of the assets. So a court, if there isn't a bond or a person can't get a bond, they might restrict the assets. What does that mean? Essentially, that personal representative is going to have to ask the court to do just about anything they want to do. That's essentially what it means. So it can really delay settling the estate. And I know when I do talk with my clients, the primary reason or primary thing that I hear over and over and over again is they want to make it as easy as possible on their loved ones when they pass. So probate, especially intestate probates, do not make it as easy as possible. Some other special considerations to really think about: children, stepchildren, adopted children, relatives that are half blood. Those types of relationships are affected when you die without a will. So typically, if you have a half blood relative, they are treated like whole blood relatives. So they're treated the same. So if you have a half sibling who's inheriting from you through intestate, they are getting a share as if they were a whole sibling. So it doesn't matter if they're half or whole. It's usually treated the same. Again, every jurisdiction is different. Adoptions, typically, if you have an adopted person in your family who is inheriting through intestate, they're inheriting the same. So say you have an adopted child, they're going to inherit the same way as your other children who might be your natural born children. Stepchildren. I usually hear a lot about stepchildren from my clients who have step grandchildren. They are not treated the same as others. They're not treated as a child. Even your step grandchild is not treated as your descendant. They don't inherit typically under intestate laws. I could only vouch again for Oregon and Washington. But so I have this happen quite a bit where they're talking about their stepchildren just like they are, or step grandchildren just like they are their other grandchildren. And they don't identify and tell me that, oh no, actually it's my son's spouse's child from a prior marriage. That we have to provide specifically under a will for them to inherit. So under intestate laws, stepchildren are not going to inherit. Another weird thing to know about, say you've done a really good job and you got your will in place, some jurisdictions will automatically revoke your will when you get remarried or when you get married. So that is also one thing to consider. So if you have your will in place and then 2 years later you meet the love of your life and you get married, but you don't ever go back and change your will, that will is revoked. And if it's a second marriage, maybe you and your new spouse intentionally are keeping assets separate, and intestate laws are going to affect what happens. So another weird issue that can come up. I have this issue come up more often than I would like to admit. I have families that are blended families, meaning that they're on a second marriage, and they might have children or nieces or nephews that they want to inherit from them. And a lot of times they'll say, oh, just give it all to my spouse. They'll do the right thing. And I got to say, in my 20 years of experience, that does the right thing. Who knows what the right thing is, for one, but also the right thing doesn't always happen. And I would say usually doesn't happen. So if you want a particular way for your assets to be dispersed, you need to get your estate planning documents in order. Just to give you a few real life examples of how intestacy caused some major conflict within families and actually just a lot of damage. I had another probate that I worked with quite some time ago now, where the person died who was single, had no children, never been married, and had a pretty nice home in a really nice neighborhood. And we didn't know who his heirs are. And we had to hire a firm, an heir search company, to go find his heirs. That was super expensive. And boy, that was really interesting process. And we had to get court permission to basically, after the heir search company did their search and performed their search, they could have kept going. But we basically had to go to the court and say, hey, court, this is what we found out. And, we can keep going here, but this is what we know now. And the court had to bless it, if you will. That took quite some time, a lot of investigative work. And let me tell you, people did come out of the woodwork pretty quickly when we filed paperwork with the court. But essentially, the sad part in my mind is not just the expense that incurred, it's that he didn't know these people who were inheriting from him. He didn't know any of them, from my understanding. And, or if he did, he met them when he was quite young. Anyway, so I think that was a pretty sad case. Another case that we had, same thing, person died, didn't have children, wasn't married in the past, and his estate partially ended up going to this beneficiary who was under government benefits and living in a government assisted facility. And basically the inheritance booted her off government assistance. And it was really challenging and sad situation. that all could have been avoided had this person thought ahead and put their wishes in place through a will. So, how do we avoid intestacy? Well, you've heard me say throughout this whole podcast, please create a will. Please, please, please create a will. You can also create a trust if you want to go further and avoid probate. In those documents, you can define who your beneficiaries are and also your class of beneficiaries. So if you have, a family, your best friend's daughter who was like a daughter to you, or goddaughter, or stepchildren, step-grandchildren, whatever it may be, you can define them in your will so that they're treated the same and included as, say, your children or grandchildren. You can also, in those blended families, those blended marriages, you can also set up your plan to ensure that your spouse is provided for, but then also ensure that when your spouse passes, your children, nieces and nephews, your loved ones, whoever they may be, will inherit whatever's remaining. So there's a lot of things that you can do to make sure that everyone gets something so they don't feel cheated, and hopefully they don't feel cheated. Those relationships can remain intact and healthy once you're gone, which ultimately is so much more important than money, right? So just some food for thought there. I hope this was helpful to you. I have so many resources talking about probate online, not just podcasts, but also free on-demand workshops that we offer have a lot more scenarios and diagrams and things like that that can really help work some of this stuff out. So I really encourage you to go to my website and check out the resources we have there. All right, that's the end for today's podcast. If you liked this podcast, I would really, really appreciate it if you give me a 5-star review on Google. And I'm always looking for more content, more information. I do this really just to help my clients and help others understand kind of the estate planning laws and things to look out for. So would love it if you can help me get the word out. That's it for today. Thanks so much, and we'll see you next time.